The original Unsolved Mysteries was a television show that used to scare the living carp out of me growing up. In fact, the show still sends chills down my spine. If you're ever out alone, driving or walking around late at night, I dare you to put on the Unsolved Mysteries theme or one of the update themes and not get a little scared. The original show ran from 1987 all the way until 2002, until the host, Robert Stack, sadly passed away. Throughout all of those years, there were several incredibly interesting cases, many of which remain unsolved even to this day. The case that I'm going to be talking about today is simply baffling and involves the US government, a contracted software company, a private investigator, and possible murder. Inslaw began as a nonprofit organization called the Institute for Law and Social Research. The institute was founded in 1973 by William A. Hamilton to develop case management software for law enforcement office automation. Funded by grants and contracts from the Law Enforcement Assistance Administration, the Institute developed a program it called PROMISE, an acronym for Prosecutors Management Information System, for use in law enforcement record keeping and case monitoring activities. When Congress voted to abolish the LIA in 1980, Hamilton decided to continue operating as a for-profit corporation and market the software to current and new users. In January 1981, Hamilton established the for-profit Inslaw, transferring the Institute's assets over to the new corporation. PROMISE software was originally written in COBOL for use on mainframe computers. Later, a version was developed to run on 16-bit minicomputers such as the DEC PDP-11. The primary users of this early version of the software were the United States Attorney's Office of the District of Columbia and state and local law enforcement. Both the mainframe and 16-bit minicomputer versions of PROMISE were developed under LIA contracts, and in later litigation, both Inslaw and DOJ eventually agreed that the early version of PROMISE was in the public domain, meaning that neither the Institute nor its successor had exclusive rights to it. In 1979, the DOJ contracted with the Institute to do a pilot project that installed versions of PROMISE in 4 U.S. attorneys' offices, 2 using the mini-computer version, and the other 2 a word processor version, which the Institute was developing. Encouraged by the results, the department decided in 1981 to go ahead with a full implementation of locally based PROMISE systems and issued a request for proposals, or an RFP, to install the mini-computer version of PROMISE in the 20 largest United States attorneys' offices. This contract, usually called the implementation contract in later litigation, also included developing and installing word processor versions of PROMISE at 74 smaller offices. The now for-profit Inslaw responded to the RFP, and in March 1982 was awarded the 3-year $10 million contract by the contracting division, the Executive Office of United States Attorneys. The contract did not go smoothly. Disputes between EOUSA and Inslaw began soon after its execution. A key dispute over proprietary rights had to be solved by a bilateral change to the original contract. This change was known as Modification 12. EOUSA also determined that Inslaw was in violation of the terms of an advance payment clause in the contract. This clause was important to Inslaw's financing and became the subject of months of negotiations. There were also disputes over service fees. During the first year of the contract, the DOJ did not have the hardware to run PROMISE in any of the offices covered by the contract. As a stopgap measure, Inslaw provided PROMISE on a timeshare basis through a VAX computer in Virginia, allowing the offices to access PROMISE on the Inslaw VAX through remote terminals until the needed equipment was installed on site. EOUSA claimed that Inslaw had overcharged for this service and withheld payments. The DOJ ultimately acquired Prime Computers, and Inslaw began installing Promise on these in the second year of the contract in August 1983. The word processor version Promise installation, however, continued to have problems, and in February 1984, the DOJ canceled this portion of the contract. Following this cancellation, the financial condition of Inslaw worsened, and the company filed for Chapter 11 bankruptcy in February 1985. And that's when things get a little juicy. The implementation contract called for the installation of the mini-computer version of Promise, plus some later modifications that had also been funded by Leah contracts, and like the mini-computer version, were in the public domain. In addition, the contract data rights clause gave the government unlimited rights in any technical data and computer software delivered under the contract. This presented a potential conflict with Inslaw's plans to market a commercial version of Promise, which it called Promise 82 or Enhanced Promise. The issue came up early in the implementation contract but was resolved by an exchange of letters in which the DOJ signed off on the issue after Inslaw assured the DOJ that Promise 82 contained enhancements undertaken by Inslaw at private expense after the cessation of Leah funding. The issue arose again in December 1982 when the DOJ invoked its contract rights to request all the Promise programs and documentation being provided under the contract. The reason the DOJ gave for this request in later litigation was that it was concerned about Inslaw's financial condition. At that point, DOJ had access to Promise only through the VAX time-sharing arrangement with Inslaw. If Inslaw failed, DOJ would be left without a copy of the software and data it was entitled to under the contract. Inslaw responded in February 1983 that it was willing to provide the computer tapes and documents for Promise, but that the tapes it had were for the VAX version of Promise and included proprietary enhancements. Before providing the tapes, Inslaw wrote, Inslaw and the Department of Justice will have to reach an agreement on the inclusion or exclusion of the features. The DOJ response to Inslaw was to emphasize that the implementation contract called for a version of Promise in which the government had unlimited rights and to ask for information about the enhancements Inslaw claimed as proprietary. Inslaw agreed to provide this information, but noted that it would be difficult to remove the enhancements from the time-sharing version of Promise, and offered to provide the VAX version of Promise if the DOJ would agree to limit their distribution. In March 1983, the DOJ again informed Inslaw that the implementation contract required Inslaw to produce software in which the government had unlimited rights, and that delivery of software with restrictions would not satisfy the contract. After some back and forth, DOJ contracting officer Peter Videnix sent a letter proposing a contract modification. Under the modification, in return for the software and data request, DOJ agreed not to disclose or disseminate the material beyond the Executive Office for United States Attorney and the 94 United States Attorney's offices covered by the subject contract until the data rights of the parties to the contract are resolved. To resolve the data rights issue, the letter proposed that Inslaw identify its claimed proprietary enhancements and demonstrate that the enhancements were developed at private expense and outside the scope of any government contract. After these were identified, the government would then either direct Inslaw to delete those enhancements from the versions of Promise to be delivered under the contract or negotiate with Inslaw regarding the inclusion of those enhancements in that software. Inslaw eventually agreed to this suggestion, and the change, referred to as Modification 12, was executed in April 1983. Inslaw then provided DOJ with tapes and documentation for the VAX version of Promise. Under this arrangement, however, Inslaw had substantial difficulty demonstrating the extent of the enhancements and the use of private funding in their development. It proposed several methods for doing this, but these were rejected by DOJ as inadequate. Inslaw's attempts to identify the proprietary enhancements and their funding ended when it began installing Promise on the USAO Prime computers in August 1983. By the end of the contract in March 1983, it had completed installing Promise in all 20 of the offices specified in the implementation contract. Since none of the available versions of Promise was compatible with the department's new Prime computers, Inslaw ported the VAX version, which contained Inslaw's claimed enhancements, to the Prime computers. After Inslaw filed for Chapter 11 bankruptcy in February 1985, there were still disputes over implementation contract payments, and as a result, the DOJ was listed as one of Inslaw's creditors. At the same time, the DOJ continued its office automation program and, in place of the originally planned word processor version of Promise, it installed a version ported to Prime minicomputers in at least 23 more offices. When Inslaw learned of the installations, it notified EOUSA that this was in violation of Modification 12 and filed a claim for $2.9 million, which Inslaw said that was the license fees for the software DOJ self-installed. Inslaw also filed claims for services performed during the contract for a total of $4.1 million. The DOJ contracting officer, Peter Videnix, denied all these claims. Inslaw appealed the denial of the service fees to the Department of Transportation Board of Contract Appeals. For the data rights claim, however, Inslaw took a different approach. In June 1986, it filed an adversary hearing in the bankruptcy court, claiming that DOJ's actions violated the automatic stay provision of the bankruptcy code by interfering with the company's rights to its software. Inslaw's initial filing claimed that the contract disputes arose because the DOJ officials who administered the contract were biased against Inslaw. The filing specifically mentioned project manager C. Madison Brewer and Associate Attorney General D. Lowell Jensen. Brewer had previously been Inslaw's general counsel, but according to Inslaw had been terminated for cause. Inslaw claimed that Brewer's dismissal caused him to be unreasonably biased against Inslaw and owner William Hamilton. Jensen was a member of the Project Oversight Committee at the time of the contract. He had helped to develop another competing case management software system several years earlier, and Inslaw claimed that this led him to be prejudiced against Promise, so that he ignored the unreasonable bias of Brewer. In February 1987, Inslaw requested an independent handling hearing to force the DOJ to conduct the adversary hearing independent of any Department of Justice officials involved in the allegations made in the hearing. The bankruptcy court judge assigned to handle Inslaw's Chapter 11 proceedings, Judge George F. Bason, granted the request and scheduled the hearing for June. Prior to the hearing, Inslaw owners William and Nancy Hamilton spoke to Anthony Prosciutto, then the Deputy Director of the Executive Office of the United States Trustees, a DOJ component responsible for overseeing the administration of bankruptcy cases. Prosciutto told the Hamiltons that the director of the EOUST, Thomas Stanton, had pressured the U.S. trustee assigned to the Inslaw case, Edward White, to convert Inslaw's bankruptcy from Chapter 11, which is reorganization of the company, to Chapter 7, liquidation. The Hamiltons had Inslaw's attorneys depose the people whom Prosciutto had named. One of them corroborated part of Prosciutto's claims. Cornelius Blackshear, then a U.S. trustee in New York, swore in his deposition testimony that he was aware of pressure to convert the bankruptcy. 2 days later, however, Blackshear submitted an affidavit recanting his testimony, saying that he had mistakenly recalled an instance of pressure from another case. Blackshear repeated his retraction at the June hearing on Inslaw's request. Prosciutto also retracted part of his claims at this hearing and said instead that he did not use the word conversion. Judge Bason, however, chose to believe the original depositions of Prosciutto and Blackshear and found that the DOJ unlawfully intentionally and willfully tried to convert Inslaw's Chapter 11 reorganization case to a Chapter 7 liquidation without justification and by improper means. In the ruling, Bason was harshly critical of the testimony of several DOJ officials, describing it as evasive and unbelievable, or simply on its face unbelievable. He enjoined the DOJ and the EOUST from contacting anyone in the U.S. Trustee's office handling the Inslaw case except for information requests. Inslaw's adversary proceeding followed a month after the independent handling hearing. The proceeding lasted for 2.5 weeks, from late July to August. In a bench ruling on September 28th, Judge Bason found that DOJ project manager Brewer, believing he had been wrongfully discharged by Mr. Hamilton and Inslaw, developed an intense and abiding hatred for Mr. Hamilton and Inslaw, and had used his position at DOJ to vent his spleen. He also found that the DOJ took, converted, stole Inslaw's enhanced promise by trickery, fraud, and deceit. Specifically, he found that DOJ had used the threat of terminating advance payments to get a copy of the enhanced promise that it was not entitled to, and that it had negotiated modification 12 of the contract in bad faith, never intending to meet its commitment under the modification. In his ruling, Judge Bason again called the testimony of DOJ witnesses biased, unbelievable, and unreliable. Bankruptcy Court Judge Bason was appointed to the District of Columbia Bankruptcy Court in February 1984 for a 4-year term. He sought reappointment early in 1987, but was informed in December that the Court of Appeals had chosen another candidate. Judge Bason then suggested in a letter to the Court of Appeals that DOJ might have improperly influenced the selection process because of his bench ruling for Inslaw. After learning of this letter, DOJ lawyers moved to recuse Judge Bason from the Inslaw case, but their motion was rejected, and Judge Bason remained on the case until the expiration of his term on February 8, 1988. In early February, Judge Bason filed a lawsuit seeking to prevent the judge the Court of Appeals had selected for the District of Columbia Bankruptcy Court from taking office, but the suit was rejected. Bason's last actions in the case were to file a written ruling on Inslaw's adversary proceeding and to award damages and attorney's fees to Inslaw. After Judge Bason left the bench, the Inslaw's bankruptcy was assigned to Baltimore bankruptcy judge James Schneider. Schneider accepted Inslaw's reorganization plan at the end of 1988 after a cash infusion from IBM. In the meanwhile, DOJ filed an appeal of Judge Bason's adversary suit ruling in the District of Columbia Circuit Court. In November 1989, Circuit Court Judge William Bryant upheld Bason's ruling. Reviewing the case under the clear error standard for reversal, Bryant wrote, "There is convincing, perhaps compelling support for the findings set forth by the bankruptcy court." DOJ appealed the Circuit Court decision, and in May 1991, the Court of Appeals found the DOJ had not violated the automatic stay provisions of the Bankruptcy Code, and that the Bankruptcy Court therefore lacked jurisdiction over Inslaw's claims against DOJ. It vacated the Bankruptcy Court's rulings and dismissed Inslaw's complaint. Inslaw appealed the decision to the Supreme Court, which declined to hear the case. Inslaw's allegations against the Justice Department led to a number of investigations, including internal department probes and congressional investigations by the Senate's Permanent Subcommittee on Investigations, or PSI, and the House Judiciary Committee. The DOJ eventually appointed a special counsel to investigate. After the special counsel issued his report, Inslaw responded with a lengthy rebuttal. The DOJ then re-examined the special counsel's findings, resulting in the release of a final department review. During these federal investigations, Inslaw began making allegations of a broad, complex conspiracy to steal promise, involving many more people and many more claims than the bankruptcy proceedings had covered. After Judge Bason's June 1987 bench ruling found several DOJ officials' testimonies to be unbelievable, DOJ's Office of Professional Responsibility, or OPR, opened an investigation of DOJ staff who testified at the hearing, including C. Madison Brewer, Peter Videnix, and EOUST Director Thomas Stanton. It also opened a separate investigation of EOUST Deputy Director Anthony Pasciutto. OPR recommended Pasciutto be terminated based on his hearing testimony that he had made false statements to the Hamiltons, but in its final report it found no evidence that the other officials investigated had applied pressure to convert Inslaw's bankruptcy or lied during the independent handling hearing. After Judge Bason issued his written ruling in January 1988, Inslaw's attorneys also complained to the DOJ's Public Integrity Section that Judge Blackshear and U.S. Trustee Edward White had committed perjury. Public Integrity opened an investigation that ultimately found perjury cases could not be proven and recommended declining prosecution. The first congressional investigation into the Inslaw case came from the Senate's Permanent Subcommittee on Investigations, or PSI. PSI's report was issued in September 1989 after a year and a half of investigation. During the investigation, Inslaw made a number of new allegations, which take up most of the PSI report. Inslaw's new allegations describe the Justice Department dispute with Inslaw as part of a broad conspiracy to drive Inslaw into bankruptcy so that Earl Bryan, the founder of a venture capital firm called Biotech, later Infotechnology, could acquire Inslaw's assets, including its software Promise. Inslaw owner William Hamilton told PSI investigators that Bryan had first attempted to acquire Inslaw through a computer services corporation he controlled called Hadron. Hamilton said that he rejected an offer from Hadron to acquire Inslaw, and that Bryan then attempted to drive Inslaw into bankruptcy through his influence with Attorney General Edwin Messy. Both Messy and Bryan had served in the cabinet of Ronald Reagan when he was governor of California, and Messy's wife had later bought stock in Bryan's company, so that Messy was willing to do this, Hamilton claimed. The contract dispute with DOJ was contrived by Bryan and Messy with the help of Associate Attorney General Johnston and Promise Project Manager Brewer. Hamilton also complained that a DOJ automation program, Project Eagle, was part of a scheme to benefit Bryan after he acquired Promise, and that an AT&T subsidiary, AT&T Information Systems, had engaged with the DOJ in a conspiracy to interfere with Inslaw's efforts to reorganize. He also told PSI investigators that the DOJ had undermined bankruptcy court Judge Bason's reappointment and had attempted to undermine Inslaw's lead counsel in the bankruptcy suit. Earl Bryan was born in 1942 and served in the Army Medical Corps in Vietnam. After leaving the service in 1970, he was appointed first as Director of California's Department of Health Care Services, or DHCS, then Secretary of Health and Welfare. During his term as Secretary, Bryan succeeded in implementing a requirement for a $2 co-payment from Medi-Cal recipients for each doctor's visit, but failed in an attempt to curtail medical benefits available under Medi-Cal when the state lost a suit brought by the California Medical Association. In 1974, Bryan resigned his cabinet post and ran for the U.S. Senate seat held by Senator Alan Cranston, Democrat of California, but lost the Republican primary. Bryan then turned to business and in 1980 established his own company, Biotech Capital, a venture capital firm that invested in companies developing medical technology. Biotech later shifted its focus to news and information services, acquiring interest in the Financial News Network, or FNN, and changing the name Biotech in 1987 to Infotechnology. In 1988, the company acquired United Press International, or UPI, one of the two major American news wire services at the time. Infotechnology encountered financial difficulties and filed for bankruptcy in 1991, as did FNN and UPI. In 1995, Bryan was charged with conspiracy and fraud for inflating the value of FNN and UPI in an attempt to secure loans to shore up the companies. He was convicted of the conspiracy charges in 1996 and sentenced to 4 years in prison. Senate investigators found no proof for any of Inslaw's new allegations. The report noted that the bankruptcy court ruling had not concluded that Johnston had engaged in a conspiracy against Inslaw and that their own investigation had found no proof that Johnston and Messi had conspired to ruin Inslaw or steal its product, or that Bryan or Hadron were involved in a conspiracy to undermine Inslaw and acquire its assets. The report did re-examine the bankruptcy finding that the DOJ had pressured the United States trustee to recommend converting Inslaw's bankruptcy from Chapter 11 to Chapter 7, and found that the EOUST director, Thomas Stanton, had improperly tried to get special handling for Inslaw's bankruptcy. He did this, the report stated, in order to gain support for the EOUST from the DOJ. The report concluded that the subcommittee found no proof for a broad conspiracy against Inslaw within the DOJ, or a conspiracy between DOJ officials and outside parties to force Inslaw into bankruptcy for personal profit. However, it criticized DOJ for hiring a former Inslaw employee, Brewer, to oversee Inslaw's contract with EOUSA, and for failing to follow standard procedures in handling Inslaw's complaints. It also criticized the DOJ for a lack of cooperation with the subcommittee, which delayed the investigation and undercut the subcommittee's ability to interview department employees. Following the PSI report, the House Judiciary Committee began another investigation into the dispute. By the time the report was released in September 1992, Inslaw's bankruptcy suit had been first upheld in the D.C. Circuit Court, then vacated by the D.C. Appeals Court. The House report thus took a different approach to several of the legal issues that the Senate report had discussed. Like the Senate report, much of the House report dealt with new evidence and new allegations from Inslaw. Inslaw's new evidence consisted of statements and affidavits from witnesses supporting Inslaw's previous claims. The most important of these witnesses was Michael Riconosciuto, who swore in an affidavit for Inslaw that businessman Earl Bryan had provided him with a copy of Inslaw's enhanced promise, supporting Inslaw's earlier claims that Bryan had been interested in acquiring and marketing the software. A new allegation was also introduced in Riconosciuto's affidavit. Riconosciuto swore that he added modifications to enhance Promise to support a plan for the implementation of Promise in law enforcement and intelligence agencies worldwide. According to Riconosciuto, was spearheading the plan for this worldwide use of the Promise computer software. Another important witness was Ari Ben Menashe, who also provided affidavits for Inslaw that Bryan had brought both public domain and enhanced versions of Promise to Israel and eventually sold the enhanced version to the Israeli government. Committee investigators interviewed Ben Menashe in May 1991, and he told them that Bryan sold enhanced Promise to both Israeli intelligence and Singapore's armed forces, receiving several $1 million in payment. He also testified that Bryan sold public domain versions to Iraq and Jordan. On the issue of Inslaw's rights in enhanced Promise, the House report found that there appears to be strong evidence supporting Judge Bason's finding that DOJ acted willfully and fraudulently when it took, converted, and stole Inslaw's enhanced Promise by trickery, fraud, and deceit. Like Judge Bason, the report found that DOJ did not negotiate with Inslaw in good faith, citing a statement by Deputy Attorney General Arnold Burns as one of the most damaging statements received by the committee. According to the report, Burns told OPR investigators that department attorneys informed him in 1986 that Inslaw's claim of proprietary rights was legitimate and that DOJ would probably lose in court on this issue. House investigator found it incredible that DOJ would pursue litigation after such a determination and concluded this clearly raises the specter that the department actions taken against Inslaw in this matter represent an abuse of power of shameful proportions. On the new allegations brought by Inslaw, although the committee conducted extensive investigations, the report did not make any factual findings on the allegations. It did include that further investigation was warranted into the statements and claims of Inslaw's witnesses. The report also discussed the case of Danny Casolaro, a freelance writer who became interested in the Inslaw case in 1990 and began his own investigation. The Democratic majority called upon Attorney General Dick Thornburgh to compensate Inslaw immediately for the harm that the government had egregiously inflicted on Inslaw. The Republican minority dissented and the committee divided along party lines 21-13. Danny Casolaro is actually the subject matter of this video. His case, which was featured on the March 10, 1993 episode of Unsolved Mysteries, to this day remains unsolved. But before it was mentioned on this episode, it was previously mentioned in the segment about a man named Doug Johnston. Also in this mix-up is a man named Charles Morgan, whose case still remains unsolved to this day, and was originally aired on Unsolved Mysteries on February 7th, 1990. 39-year-old Chuck Morgan was a successful businessman who was the president of his own escrow agency. He was also a potential witness in a state land fraud case involving a known crime boss. On March 22, 1977, he left his Tucson, Arizona home to drive two of his daughters to school. After dropping them off, he vanished. 3 days later, he arrived back at his home. According to his wife Ruth, he was missing a shoe, had a plastic handcuff around one ankle, and had his hands tied together with a plastic zip tie. He could not speak, but with a pen and paper, he wrote down that he had been kidnapped and tortured. He also wrote that a hallucinogenic drug had been painted on his throat. He claimed that this drug would drive him insane or kill him if he ingested it. He asked Ruth to move his car because he did not want them to know that he had returned home. However, he would not say who they were. He also told her not to call the police because a hit would be put out on the lives of them and their family members. For 1 week, Ruth nursed Chuck back to health by feeding him with an eyedropper. Before his voice returned, he began to allude to his secret identity. He claimed that he had worked as an agent for the federal government and he fought against organized crime. He also claimed that they had taken his treasury identification. He said that he escaped from his captors near Phoenix's Sky Harbor Airport. After his kidnapping, Chuck became justifiably paranoid. He began wearing a bulletproof vest. He also started driving his daughters to and from school. He informed the school that nobody else should be allowed to pick them up. On June 7th, 2 months after his initial disappearance, Chuck vanished again. Shortly before his second disappearance, he told his father that if anything were to happen to him, there was a letter he had written that would tell them who was responsible. The letter was never found. However, 9 days later, an unidentified woman called Ruth and said, "Chuck is all right." Ecclesiastes 12:1-8. This is a reference to a Bible passage, which reads in part, "Men are afraid of a high place and of terrors on the road. Remember him before the silver cord is broken and the golden bowl is crushed. Then the dust will return to the earth as it was, and the spirit will return to God who gave it." 2 days later, Chuck was found shot to death despite the fact that he was found wearing a bulletproof vest. His body was found in the desert 30 feet off the highway in the San Juan Springs area. He had been shot once in the back of the head with a bullet from his .357 Magnum, which was lying beside him. No fingerprints were found on it. Gunshot residue was found on his left hand, indicating he had fired a weapon. In his car, police found a note that had directions to the crime scene written in his handwriting. Also found in the car were several weapons, ammunition, and a CB radio. Strangely, a piece of one of his teeth was found wrapped in a white handkerchief in the back seat. A pair of sunglasses was also found that did not belong to him. Strangely, Chuck had clipped a $2 bill inside his underwear. Written on the bill were 7 Spanish names from the letters A to G. Also, Ecclesiastes 12 was written, with the verses 1 through 8 marked by arrows drawn on the bill's serial number. This was the same reference that the female caller had made to Ruth. On the back of the bill, the signers of the Declaration of Independence were numbered 1 through 7. Also, a crude map was drawn, which shows several roads between Tucson and the Mexican border. The towns Robles Junction and Sasabe were marked. These towns are apparently known for smuggling. 2 days after Chuck's death, an anonymous woman spoke to an officer for the Pima County Sheriff's Department on the telephone. She claimed that he was supposed to meet her at a local motel shortly before he died. She claimed that her nickname was Green Eyes and that she was the same woman that had called Ruth several days earlier. She also claimed that at the motel, Chuck showed her a briefcase containing several $1,000s in cash. He said that the money would buy him out of a gang contract that had been put on his head. Surprisingly, despite the bizarre evidence, authorities ruled that Chuck committed suicide. They believed that he did so either because of financial difficulties or fears for his safety. His family and a reporter named Don Devereaux believed that he was murdered. Some investigators also suspect that his death was not a suicide. Shortly after Chuck's death, his impounded car was broken into while it was in police possession. Around that same time, his office was also ransacked. 3 weeks after his death, 2 men claiming to be FBI agents arrived at the Morgan home. They told Ruth that they had to look through the house. They tore the house apart and searched for quite a while. It is unknown if they ever found anything or if they were even FBI agents. When Devereaux contacted the FBI, they claimed that they had never even heard of Chuck Morgan. There are several rumors surrounding this case, including that Chuck was killed because he was involved with illegal activity or was doing secret work for the government. His death seems just as unexplained as the events leading to it. Although Chuck claimed that he was working against organized crime, some believe that he was actually involved with it. During the 1970s, Tucson, along with other cities in Arizona, became a place that the mafia moved to due to its warm climate and controversial criminal justice system. Led by former New York Don Joseph Bonanno, more than 500 racketeers moved to Tucson during the 1970s. Their influence led to several gangland-style killings in the area, one of the more famous being the murder of investigative reporter Don Bowles. What made Arizona most attractive to crime syndicates was a unique state law that allowed them to buy land through numbered blind trust accounts. This would allow them to remain anonymous and successfully launder money. Chuck did real estate escrow work for at least one mafia family. They may have used him to do escrow work for purchases of gold bullion and platinum. This was a more convenient way for them to launder money. Starting in 1973, it appeared that he was doing several $1 million of escrow work in bullion and platinum. In reality, there was no bullion or platinum. Instead, the money was moved through several escrow accounts and legitimized. On one occasion, Chuck mentioned to Ruth that money laundering was occurring in Tucson. However, he claimed that he was not involved in it. He also stated that the less she and the children knew about his activities, the better it would be for them. It is theorized that Chuck Morgan was killed by members of organized crime in the Tucson area. It is possible that the mafia family that he worked for had him killed because he knew too much. One theory is that organized crime bosses put the word out that they wanted Chuck dead. A hitman then told Chuck, so he came up with the money in order to buy the hitman off. However, when the two met in the desert, the hitman killed him anyway and took the money. This theory has not been confirmed. Although it was not mentioned in the segment of Unsolved Mysteries, Chuck was a secret witness in an extensive land fraud investigation and was interviewed about it in May 1977, shortly before his death. It is not known if this had anything to do with his death. Also not mentioned was that Chuck had been seen at several restaurants and motels on the west side of Tucson after his disappearance and before his death. After the case aired, Unsolved Mysteries received several calls relating to Chuck's death. Don Devereaux investigated several leads that came up as a result of the program. He learned that Chuck was heavily involved in money laundering activities through his Tucson escrow company. From 1973 to his death in 1977, he was also involved in large gold and platinum transactions. He apparently received a large amount of money from these activities, and some of this money allegedly came from Southeast Asia. Devereaux discovered that Chuck kept duplicate records of the illicit transactions. Devereaux now believes that Chuck was killed because he still had these records. 3 months after the broadcast, Doug Johnston was found shot to death in his car outside of his Phoenix office. Interestingly, he worked across the street from Devereaux's office and drove an almost identical car. Devereaux now believes that he was supposed to be killed instead of Doug. A year after Doug's murder, Devereaux was contacted by a writer from D.C. named Danny Casolaro. He agreed to share with him the information that he had uncovered about Chuck's illegal gold transactions. However, Danny died suspiciously before he received the information. All 3 cases remain unsolved. At 11 p.m. on May 14, 1990, 35-year-old Doug Johnston left for his night shift at a computer graphics company. An hour later, he was found shot to death in his car in the company parking lot. He had been shot behind his left ear from a distance of at least 12 inches. At first, authorities believed that his death was a suicide. However, he was right-handed, there was no powder residue on his hands, and most importantly, there was no gun found at the scene. For unknown reasons, authorities have not determined that Doug's death was either a suicide or a homicide. His family and friends are convinced that his death was a homicide. They do not believe he would have committed suicide because he had just finished school and gotten a new job. He was also very close to his family and friends. Interestingly, Doug had a similar house and drove a similar car to Don Devereaux, who lived across the street from the parking lot where Doug was killed. He was a journalist whose work was allegedly a threat to mob figures in Phoenix. He was also investigating the suspicious death of Charles Morgan. In 1991, Devereaux was contacted by a writer from Washington, D.C. named Danny Casolaro. Devereaux agreed to share with him the information that he had uncovered about Charles's money laundering and gold transactions. However, before Devereaux could even mail his research, Danny was found dead with his wrists slashed in a hotel bathroom. His death was ruled a suicide, but Devereaux believes that he was murdered. 6 months after Danny's death, Devereaux learned from another journalist that there was a hit placed on him, but that Doug was mistakenly killed as a result. Devereaux also learned that there were apparently other people that wanted him dead. A CIA official and an informant for Israeli intelligence confirmed the death threats to him. At 12:30 p.m. on August 10, 1991, 44-year-old investigative reporter Danny Casolaro was found dead in his hotel room near Martinsburg, West Virginia. A maid had found him in his bathtub. Both of his wrists had been slashed several times. Police were called in to investigate. They soon found an apparent suicide note that read, "To my loved ones, please forgive me, most especially my son, and be understanding. God will let me in." In the bathtub, they found a razor blade. It was determined that Danny's wrists had been slashed a total of 12 times. There were 8 cuts on his left one and 4 on his right one. One cut was deep enough to sever a tendon. Investigators found his wallet with credit cards and money still in his room. There appeared to be no signs of forced entry or a struggle. As a result, they ruled his death a suicide. For unknown reasons, his family was not notified of his death for 2 days. They're convinced that he was murdered. When Danny's brother, Tony, contacted the police, he was stunned to learn about the day in notification. He asked about Danny's papers, his investigation, and his overall life. The officer did not know about any of it. The papers that he had had with him included hundreds of notes and documents from his year-long investigation. They have never been found. Danny's family also noted that he was afraid of blood tests and needles, so they felt that it would be unlikely that he would commit suicide by slashing his wrists. Just days before his death, he told several friends that he was close to breaking the story that he had been investigating. It started as an inquiry into a computer software theft. However, it soon turned into an investigation of government corruption that allegedly implicated U.S. Justice Department officials. Some believe that he was killed because he knew too much. His investigation began in August 1990 when he interviewed Bill and Nancy Hamilton, the owners of a computer software company called Inslaw. They had developed a powerful program called Promise that allegedly revolutionized information management for law enforcement agencies. In 1980, the U.S. Justice Department purchased Promise to handle their millions of case files. Initially, it worked well with the department. However, during the second year of their 3-year contract, the Justice Department began to withhold payments from Inslaw. This eventually led to Inslaw filing for bankruptcy. Bill and Nancy discovered that the Canadian government had acquired Promise, despite the fact that they did not sell it to Canada. Bill and Nancy spoke to Michael Riconosciuto, who claimed to have worked with the CIA on numerous top-secret projects. He claimed that people involved in covert operations in South America and the Middle East had distributed Promise. He also claimed that the money received from selling it was used for other covert operations. In August 1989, the Inslaw scandal became known to Congress, and the House Judiciary Committee opened a formal inquest. Riconosciuto testified about his knowledge regarding the case. Within a week of submitting his sworn affidavit to the committee, he was arrested on drug charges by agents of the Justice Department. Former Attorney General Elliot Richardson also testified before the committee. After months of investigation, Danny believed that he had uncovered an unsavory network of U.S. officials, organized crime members, and intelligence agents. He called the network the Octopus. He claimed that it was behind several scandals of the 1980s, including the Iran-Contra scandal, the BCCI scandal, the BNL affair, and the now discredited October surprise. He was apparently in contact with several shadowy figures. A week before his death, Danny told Tony that he had been receiving frequent death threats. He also said that if he did die, that Tony should not believe that it was an accident. On August 8, 1991, he arrived in Martinsburg with several briefcases, planning to meet with informants and conclude his investigation. He claimed to have been tracking the finances of the Octopus and believed that one of his new contacts would deliver new evidence. Some of it would include IRS printouts of certain individuals. The day before his death, Danny met with another source, William Turner, who was a former employee of a major defense contractor. According to him, he handed over paperwork describing corruption that Danny believed was tied to the Octopus. The next day, Danny was dead and William's document were missing, along with the rest of Danny's papers. Due to the controversy surrounding Danny's death, the West Virginia authorities convened a formal inquest, which included a complete autopsy. Tony claimed that Danny had been embalmed without the family's permission. The autopsy confirmed that bleeding from the wrist cuts were the cause of his death. It also suggested that he was not alone at the time. Specifically, there was a bruise on his arm and head. Also, the tips of 3 of his fingernails were missing. Danny's family learned that his hotel room was cleaned by a professional cleaning crew the day after his death. They inadvertently discarded important evidence. Interestingly, one of them remembered seeing 2 bloody towels in the bathroom. It appeared that someone had tried to clean the blood off the floor prior to when the professional crew arrived. One strange footnote to this case occurred at Danny's funeral. During the burial, a highly decorated military official appeared and placed a medal on his casket. Nobody knows who he was or what connection he may have to this case. Danny's family and many others are convinced that his investigation into Inslaw and the Justice Department led to his death. Several people believe that Danny was murdered by a secret clandestine government agency dubbed the Octopus, but such a presence is unconfirmed at best. His family believes that they killed him because he learned too much during his investigation of Inslaw and the U.S. Justice Department. In October 1991, William P. Barr succeeded Dick Thornburg as Attorney General. In November, Barr appointed retired federal judge Nicholas J. Bua as a special counsel to investigate the allegations in the Inslaw case. Bua was granted authority to appoint his own staff and investigators, to impanel a grand jury, and to issue subpoenas. In March 1993, he issued a 267-page report. The report concluded that there was no credible evidence to support Inslaw's allegations that DOJ officials conspired to help Earl Bryan acquire Promise software, and that the evidence was overwhelming that there was no connection between Bryan and Promise. It found the evidence woefully insufficient to support the claim that DOJ obtained enhanced Promise through fraud, trickery, and deceit, or that DOJ illegally distributed Promise inside or outside of DOJ. It found no credible evidence that DOJ had influenced the selection process that replaced Judge Bason. It found insufficient evidence to confirm the allegation that DOJ employees sought to influence the conversion of Inslaw's bankruptcy or commit perjury to conceal the attempt to do so. Finally, it concluded that the DOJ had not sought to influence the investigation of Danny Casolaro's death, and that the physical evidence strongly supported the autopsy finding of suicide. Bua's report came to a number of conclusions that contradicted earlier proceedings and investigations. Judge Bason had found that DOJ's claim it was concerned about Inslaw's financial condition when it requested a copy of Promise was a false pretext. Bua rejected this finding as just plain wrong. The House report had cited Deputy Attorney General Burns' statements as evidence that DOJ knew it did not have a valid defense to Inslaw's claims. Bua found this interpretation entirely unwarranted. Bua was particularly critical of several of Inslaw's witnesses. He found that Michael Riconosciuto had given inconsistent accounts in statements to the Hamiltons, his affidavit, and in testimony at his 1992 trial for manufacturing methamphetamine. Bua compared Riconosciuto's story about Promise to a historical novel, a tale of total fiction woven against the background of accurate historical facts. Bua found Ari Ben-Menashe's affidavits for Inslaw inconsistent with his later statements to Bua, in which Ben-Menashe said that he had no knowledge of the transfer of Inslaw's proprietary software by Earl Bryan or DOJ, and denied that he had ever said this elsewhere. Ben-Menashe said that others simply assumed that he was referring in his previous statements to Inslaw's Promise, but acknowledged that one reason he failed to clarify this was because he was going to publish a book, and he wanted to make sure that his affidavit was filed in court and came to the attention of the public. Bua also noted that the House October Surprise Task Force had examined Ben-Menashe's October Surprise allegations and found them totally lacking in credibility, demonstrably false from beginning to end, riddled with inconsistencies and factual misstatements, and a total fabrication. He specifically observed that the task force found no evidence to substantiate Ben-Menashe's October Surprise allegations about Earl Bryan. Inslaw responded to the Bua report with a 130-page rebuttal and another set of new allegations in an addendum. These allegations included the claim that the DOJ's Office of Special Investigations was a front for the Justice Department's own covert intelligence service, and that another undeclared mission of the Justice Department's covert agents was to ensure that investigative journalist Danny Casolaro remained silent about the role of the Justice Department in the Inslaw scandal by murdering him in West Virginia in August 1991. By this time, Janet Reno had succeeded Barr as Attorney General after Bill Clinton's election as president. Reno then asked for a review of Bua's report with recommendations on appropriate actions. In September 1994, the department released a 187-page review written by Assistant Associate Attorney General John C. Dwyer, which concluded that there is no credible evidence that department officials conspired to steal computer software developed by Inslaw Incorporated, or that the company is entitled to additional government payments. The review also reaffirmed the earlier police findings that Casolaro's death was a suicide and rejected Inslaw's claim that OSI agents had murdered Casolaro as fantasy with no corroborative evidence that is even marginally credible. In May 1995, the United States Senate asked the U.S. Court of Federal Claims to determine if the United States owed Inslaw compensation for the government's use of promise. On July 31, 1997, Judge Christine Miller, the hearing officer for the U.S. Court of Federal Claims, ruled that all of the versions of promise were in the public domain and that the government had therefore always been free to do whatever it wished with promise. The following year, the Appellate Authority, a 3-judge review panel of the same court, upheld Miller's ruling and in August 1998 informed the Senate of its findings. A 1999 book by the British journalist Gordon Thomas titled Gideon's Spies, The Secret History of the Mossad, repeated the claims of Ari Ben-Menashe that Israeli intelligence created and marketed a Trojan horse version of promise in order to spy on intelligence agencies in other countries. In 2001, The Washington Times and Fox News each quoted federal law enforcement officials familiar with debriefing former FBI agent Robert Hansen as claiming that the convicted spy had stolen copies of a promised derivative for his Soviet KGB handlers. Later reports and studies of Hansen's activities have not repeated these claims. So do you think that the DOJ stole the promised software from Inslaw? What of Ari Ben-Menashe's claims? Is Michael Rakana-Shuto a believable source? And what of Danny Casolaro, Doug Johnston, and Charles Morgan? It's so interesting to me how a court case involving payments over government software weaved so many webs. How one murder led to another, which led to another. Who is guilty and who is innocent? Perhaps we'll never know. Subscribe.